Bow with me. Our gracious Heavenly Father, we just thank you for this day and its beautiful sunshine, that we might come together and do your work. Keep in mind all of our soldiers overseas and keep them out of harm's way, and be with each and every one of not only our Cherokee citizens, but all the citizens that are still without power and struggling day to day. Please guide and direct us that we might do your will. In Jesus' name we pray.
Amen. Thank you, Mr. Baker.
Meredith Rayleigh. Here. Bill England.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Buzzard.
Here.
Julia Coates.
Here.
Bradley Cobb. Joe Crittenden. Jody Fishingham. Janelle Fulbright. Don Garvin. Chuck Hoskin Jr.
Here.
China Glory Jordan. Curtis Snell. Chris Stokes.
Here.
David Thornton. Sarah Callan Watts.
Honey,
We do have a quorum.
we have a quorum. Next order of business is approval of the December regular session minutes.
I move to be approved.
Moved in second. Any discussion on approving the minutes as written? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carries.
Madam Chair,
Yes, Mr. Buzzard.
I'd like to amend the agenda to include a waiver of sovereign immunity as it applies to this nursing home in Jay that we talked about 2 months ago, and I'd like to put that on the agenda
Under new business.
under new business as a new item.
Second. Does everyone have a copy?
They're getting copies for everyone right now.
And what's the title of it?
The title is Waiving of Sovereign Immunity as it applies to the Banksburg and Cherokee Nation Home Health Services Industry Loan Agreement.
Have a motion and a second. Any discussion on amending the agenda to include this item 3 under new business? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. That'll be item 3, Mr. Buzzard.
Thank you.
Next is report, and Miss Wright is ill. I did get a message. We do have her report. So if there's no questions or any items to discuss on that, we'll move on down to the Justice Department. Ms. Hamlin.
Thank you, Madam Speaker. Good afternoon. We have submitted our report. I'll be happy to answer any questions. A couple of new items. I'm sure you all know we filed in the Northern District of Oklahoma a federal lawsuit on the Freedman issue. That was filed, I believe, the day before yesterday. The filing of that federal case should not undermine the tribal court case, which is proceeding. All the briefs are in for summary judgment on that case, and it's before the court. I expect the court will probably set it for argument. But this case, the filing in the Northern District, represents the fulfillment of our promise to certain congressional leaders that we would put the issue to the federal courts on the dispositive issue of what the Treaty of 1866 did. It doesn't address any tribal right to citizenship. It centers around federal rights, if there is one. And as you know, the Cherokee Nation is no longer a party in the District of Columbia case, District of Columbus case, and so the only thing that's remaining in that is an action against the officers, and we filed a motion to dismiss on that also. So that was filed day before yesterday, I believe. The other new thing that I wanted to talk to you about briefly is the Cossey decision from the Oklahoma Supreme Court that came out regarding a tort claim against Cherokee Nation Enterprises at one of our casinos, basically involving a fall by an individual. Went through Rogers County and then went up on appeal to the Oklahoma Supreme Court. The decision is bad, and it is a plurality decision. The attorneys will understand what that means. What that indicates is there was no majority of the court to arrive on a decision or a theory about the law of the case. There's a plurality of decisions. So you don't have a majority coming down on any one thing. I don't remember the split without looking at it, but it could be 4 say this and 3 say this and 2 say this. There are other cases before the Oklahoma Supreme Court. The Choctaws have 2. They expect the same decision. I've met with CNE, I've met with the Attorneys General and General Counsels for the other 4 tribes, and we've all talked about what to do about this case. The Choctaws are moving for a stay in their pending cases. I don't know if they'll receive that or not. They are also invoking the beginning steps of arbitration on the Class 3 compact. They would like for the other tribes to do the same thing. We're in a bit of a difficult situation because we now have a state court decision against us. We will be seeking rehearing for that, and are going to be filing for an extension for rehearing so that everyone can coordinate their efforts and present a unified front to the state government. One interesting thing about this case, the crucial issue is who has jurisdiction to decide these sorts of court claims that occur at the casinos. And the court found the state courts of Oklahoma courts of competent jurisdiction. That is not what the tribes intended, and the governor and the treasurer executed affidavits to the extent that that was not what they understood either, that it would not be the state courts that were courts of competent jurisdiction, but rather the tribal courts. The Supreme Court did not accept those affidavits. We see this as probably just the beginning or indicating an attitude of the court to chip away at tribal sovereignty. I personally think that it is a reflection of the economic situation in the state and across the United States when you see headlines about the governor telling the state agencies to tighten their belts, that there are going to be budget cuts, when we see major corporations in the state falling, and then the Indian casinos are building and expanding. I think that this represents a backlash against us, and I suspect that we will unfortunately see more of the same. I'll be happy to answer any questions about those 2 relatively new issues and or anything else on the rules report.
Mr. Hopkins, and then Ms. Jordan.
Thank you, Mr. On the tort case, you said the affidavits weren't accepted by the Supreme Court. I take it they weren't entered at trial.
They were not.
Is it theoretically possible for us to compact our way out of this situation?
Theoretically possible. We could.
Going down the road, that is.
Right. That we could, we being, the gaming tribes. I think that we would have much more likelihood of doing anything together than separately. That and all of the Class 3 compacts are basically the same. They have some differing provisions, but they're pretty uniform. We could go back and try to renegotiate. When we talked about that at our meeting with the 4 other tribes, everyone seemed to think that it was not the time to try to get something new through the legislature, and that it was very difficult the first time. One of the things that I had thought about, and I don't know if this can happen or not, was perhaps doing an addendum to the compact, just reflecting what a court of competent jurisdiction means. If the governor's office agrees with us as to what we all thought it means, can we not just file an addendum clarifying that, and maybe that would go through easier? I don't know, but there are different options that we're looking at, and if anyone has any thoughts, resolution or ways to address this, certainly welcome any and everything.
And then just a couple of follow-ups. With respect to the Northern District, the federal court action, is that in-house, or are we using any outside counsel for that?
Using outside counsel and in-house. Dean Lizzie and Paul Estel out of Tulsa, and I were both signatories on that.
And at this point in the fiscal year, are you where you thought you would be in terms of how much we're spending on outside counsel versus bringing stuff in-house?
I think so. I haven't run a report. I know that the attorney fee bills from the Washington firm have dropped dramatically. $6,000. I remember one of the last bills was $6,000. And I'm sure you recall we had months where they were the six-digit figures. Those have dropped dramatically. My knee-jerk response is where I am where I thought I should be, or maybe even a little ahead of the scale.
Given where the tribal court suit is, do you anticipate that we'll get a decision in it before the Northern District rules on the new lawsuit?
I think we'll get a decision from the district court of the Cherokee Nation. Whichever way that district court decision goes, it will go up to the Cherokee Nation Supreme Court. So whether or not we have an ultimate resolution from the tribal court before the federal court, I wouldn't hazard a guess.
Thank you, Minister.
Ms. Jordan?
Could you bring us up to rights, or bring us up to date on that water rights case?
Yes. The poultry lawsuit, the poultry industry, Tyson Foods, and the other defendants filed a motion to dismiss against the state of Oklahoma, alleging that the Cherokee Nation was an indispensable party because we actually own the water rights to the Illinois River watershed. The waters within our geographical boundaries are ours, not the state of Oklahoma, so the state of Oklahoma doesn't have the power to enforce, and they're not the proper party in the lawsuit. The state of Oklahoma responded. We talked to the Attorney General's office quite a bit before they filed their response. They took some of our suggestions in hand. They filed a response. It still is not what we would have liked, but it did acknowledge that we had some claim to the water. They, if you will, watered down their acknowledgement of that much more than we would have liked, and suggested that maybe it was just only a riparian interest, and that's not what we claim. Then the poultry industry has filed a reply to that response. So all the filings are in, and we have not filed anything. We have a brief that's being prepared in-house, and we still are not certain if that is going to be filed as an amicus in the district court case, or as some sort of intervention motion, or as some sort of motion to dismiss based on indispensable party, like the poultry folks claim. You know, there are different interests. We do believe the water's ours. However, we don't necessarily want all the hard work that's gone into that lawsuit just to die without resolution. So we're trying to balance all those interests. We're dealing with the AG's office. I talked to the Tyson Food folks this morning. So that's where it's at.
So, Diane, right now, is it better, it is probably better for us to stay on the fringes, because this is not the real case we were looking for, right? On establishing our rights?
We had chosen not to enter this case just because we knew what complex litigation that it was going to be. And, you know, the assertion of our rights is separate to any pollution allegation. And we would, you know, in a perfect world, we'd like to have a lawsuit where we're just talking about that.
If we do an amicus brief, we won't be in the lawsuit per se.
That's right. So we won't be subject to discovery, all of that sort of thing. That if we enter as a party, we'll be bound by the decision, and we will be subject to discovery, and it will delay the lawsuit, I'm sure.
Could you maybe just give us a timely update monthly on
Certainly.
that? Just let us know what's going on.
Certainly. And Mr. Hembry has talked to me about that and tried to keep him apprised of what's going on.
Mr. Hembry, did you have a question or a statement?
Yes, in particular as to the Cossey decision, you know, when I discovered it, I made sure that a copy was forwarded to all the council. Can't stress enough that I would encourage you to read and digest this opinion. It's a very, very important decision as to tribal sovereignty in Indian country. What is, you know, they found that the state of Oklahoma is a court of competent jurisdiction, all this, but also there is language in there that seems to attack tribal courts and being a court of general jurisdiction. And it is something that, outside of the compact itself, is very detrimental to the tribal sovereignty. And it's something that we need to have a game plan to address, because this is just, we had the Blythe decision earlier about the Dram Shop Act, and whether there was the Supreme Court ruled that there was a limited waiver of sovereign immunity because they applied because the tribe applied for a liquor license. Diane is right, pardon, Madam Attorney General is right, that this is not the end of it. Blythe is one. This is another step. There's going to be other steps, and we need to have the ability to plan to protect our sovereignty, because this case is good, is being disseminated across the United States. Okay, and other state courts are going to be looking at it, and it's going to, it's sort of a bigger picture here. But one thing that I also wanted to state, and no reflection on Diane, but I was chagrined as counsel for the tribal council, is that the first time I learned about this lawsuit was reading it in the bar journal. This is a case of major import to the government of the Cherokee Nation, and we don't get any reports on it in any report from CNE or anywhere else until the decision is made. I know the firm involved in this is a very competent law firm, but I would hope that, and like I said, it's not on Diane's end of it, but I hope that if there are other cases out there like this from CNE, that we get a report on the litigation, and get to know ahead of time, because the more ideas we could have injected on the front end of this case, is better than dealing with the aftermath, and that's the only point that I would make.
No, and it's a point well taken. We didn't do this case. Stratton Taylor's firm out of Rogers County did it. They did it on behalf of CNE. CNE hired them, and they handled the lawsuit. I didn't know about the lawsuit, and they have tried to keep me apprised of it. I will say that in the last few months that our interaction with the entities and the legal cases going on with the entities has gotten, it's much more frequent now, and it will be more frequent in the in the future. And that is, you were trying to say it's not my fault, it is my fault. I should have been more on top of it at the governmental level, and we should report on it.
Mr. Austin?
But to your point, Todd, the question I asked a while ago was the evidence that a court of competent jurisdiction, according to the compact, include Cherokee Nation courts. That evidence wasn't put on a trial. I'm not looking to armchair quarterback the thing, but is that something, if we'd have known on the front end, we might have taken a proactive stand on that, or would that have mattered at the end of the day?
Well, first, the way the lawsuit is situated is that there hasn't been a trial yet. Okay, there was the suit was filed. CNE has filed a motion to dismiss for failure to based on sovereignty, failure to join the necessary party, and they can't be joined. Judge Post ruled against CNE, and then that question was certified. Okay, now it's going to be remanded back. Now, the plurality opinion, but especially the opinions of Justice Calder and Edmondson, I think opens the door that we can maybe interject some of that evidence at trial, or now, because their concurring opinion, I think, left several doors open in that regard. So the battle's not over with. It's not like we were appealing a final decision. Now we go back and they decide on the merits, and plus, I think we could bootstrap some additional evidence and maybe get a second bite of the apple based on Edmondson and Calder's concurring in part and dissenting in part, which would change the balance of the decision in certain respects.
That's, I guess, one of the few good things about it being a plurality decision is because the way the court is split on rehearing, we feel like we at least have some shot into swaying some of those votes. Particularly one of the, I think, best written opinions is by Justice Colbert, who was going just down the line where we wanted him to go and then split off. So perhaps if we can get that vote with Justices Cogger and Edmondson. As to your, if we'd known on the front end, could we have made different arguments or affected it? I don't think so in this case. I truly don't. I think that the court was looking for a case and ours got there before anybody else's. That seems to be the consensus of the other 4 tribes too.
Any other questions, comments? Thank you very much.
I'd like to make
Just
a
moment, I'm
comment.
sorry, Mr. Buzzer.
And this is just a comment, I picked up on what you said, Diane, about you seeing, you may be the one to blame the off the ball and not getting it. I don't see it that way. I see this council and administration as a Cherokee Nation. I see our seasoning industry, CNI, and all components. They should know that they should contact the Cherokee Nation because we're the ones putting the name out there. So I think we should have instructions to all of our CEOs that they need to be apprised of that. Now, the reason I say that is because when I was in the programs, I had the same dealing that you had. I'm not saying that we want to go in and take over the operations or even do that. What I'm saying is that they need to realize, the Cherokee Nation's at the forefront of everything. This is like this lawsuit. They should have notified you instead of you have to keep up with them. So I just think we need to send a message to the CEOs that, they need to keep us apprised, at least the administration and the council about it, because I've seen this happen more than once. Thank you.
Gordon?
Well, as a single shareholder of those corporations, I think they have a duty,
All right.
when they come and report to us every month, to apprise us of what pending lawsuits they have. Not only should she be in the loop, and she should have been able to participate in that lawsuit, because who knows more our position than our Attorney General, Stratton Taylor's group, wouldn't know more than she would know on what our position would be in those lawsuits. They should be reporting to her, and they should be reporting to us on a monthly basis.
Do they report to you, Diane, on a monthly or on a consistent basis?
They do now. In the past, it's been more ad hoc, and I wasn't just trying to moderate it down. It has gotten a lot better recently, and I sent out copies of the AG Act to the entities within the last 2 weeks after the Cossey decision, which says that the AG's office directs the litigation for the nation and all of its entities. So I think we're making headway. We had a meeting yesterday with the entities and tried to stress some of this, and the councilman's comments are well taken. That's a problem that everyone has what they're supposed to be doing, and silos can be built. We're working on it.
And you start the floor, Mr. Gordon.
I would ask the speaker if she has the ability to do this, to direct those corporations to make a part of their report any pending litigation, and to update us on that on a monthly basis.
We can do that. Mr. Embry, did you have another comment?
That was going to be the comment I was going to make. I think it would be appropriate for the entities, when they report in executive finance, is to give a litigation report. These are opinion cases, and some of them will be, trifle, and we may not be concerned with them. But, this one involves, this case greatly diminished the sovereignty of Indian tribes statewide, and we need to have a hand in that type of litigation.
Any other questions? Ms. Hammonds? The report, thanks. Election Commission, we do have that report in our book. Todd is the attorney for the Election Commission, Lloyd Cole. Is that Lloyd Cole from Stillwell?
The one and only.
Okay. Tax Commission, Ms. Wexton?
I believe you have my report in front of you. I'll try to answer any questions if you have any.
Any questions for Ms. Wexton?
Madam Chair.
Ms. Buzzard?
Yes, I have a question, clarification, Chairman. I had a person asked me the other day, they had a personalized tag to the Cherokee Nation. And then when he renews the car tag, then he pays for renewal of the personalized tag and also the regular car tag.
You have to renew both.
But he only gets one sticker test.
He
He
should
doesn't
get,
see why he has to pay for that personalized tag every year.
he should get a sticker for the personal, I'll check on that, but you have to renew both. Both tags have to be renewed.
Okay,
Because your
and I guess
personalized
his
tag
question
does not
was
cost that.
why I'm only getting one sticker.
I'll find out on that one. But
Just
yeah,
let me
you
know.
have to renew both.
Okay, all right, thank you.
Any other questions? Thank you very much. Ms. Hanby, self-governance. Afternoon, Vicki. Afternoon.
Well, you should have my report, but just one brief update on contract support cost. I reported that we completed that negotiation, and it's been included in the 08 shortfall report for IHS for 08. And in 09, Hastings will become part of that shortfall report. And in total, we added an additional $10,394,000 for contract support cost shortfall. And what that does is put us in a better position should more funds be appropriated for contract support. And in that regard, we've been working with Lloyd Miller and his firm, along with the Speaker's favorite attorney. She's winking at me. But we've been working with Lloyd Miller as well as some other tribal leaders. There was a meeting with Senator Inouye. I was in the middle of the ice storm at that time, and Melanie Knight, the Secretary of State, and the Deputy Chief were planning to attend that meeting and was unable to due to the ice storm. But we did have Paula Ragsdale attend. That meeting went really well. And Senator Inouye is trying to add some funds for contract support costs in the stimulus bill. Even today, we've been receiving some emails in that regard to try to garner support for that. So I just wanted to update you on that not only do we have that in the shortfall report now, to where that if funds are appropriated, we are in a good position, but we're also working to try to get those appropriations as well.
Great. Any questions, comments for Ms. Hanby? Yes, Dr. Cobb?
Are we getting any favorable listening ears up in D.C. on this road funding formula issue we're having? Some of the tribes out west were suggesting we change the funding formula for roads. I know it's in your report, and it didn't work with the roads department, but you know what I'm talking about. Some of the tribes, they want to change the funding formula, which puts us in a bad spot.
Right. We have been working with the Washington office as well as the roads department to address that issue, and we're looking at it on several different aspects. But of course, from Oklahoma, you know, our delegation is certainly in support of that, and it really comes down to large land-based tribes, and of course they have the support of their congressmen and senators. So.
So it's going to come down to our congressman and their congressman.
That's part of it, yeah.
That's what I want to know.
But we are holding our own, and we've got a plan as to how to address that on different fronts.
Thank you.
Any other questions?
Just a comment on that, please.
Mr. Buzzard?
And just a comment on that, Vicki. I think what it's really going to boil down to is Oklahoma is considered a you know this stuff, but Oklahoma is considered a non-reservation state, and you have all the other tribes that are reservation Indian tribes. And right now, they want to get the term reservation will define, and what they're going to do is define it for Oklahoma is not a reservation and receive those funds. We had fought this spot back in the early 90s to get it changed, but they're always chipping away to get things back for more money, because actually Oklahoma's come a long way in the last 8 to 10 years. It's come from like a $20 million IRR road funding up to $52 million now. So it's a money thing for the other side. Thank you.
And it would mean a great deal of money to Oklahoma. Thanks, Ms. Hamby.
Is there anyone here from Gaming Commission?
I'm here, and if you have any questions, I'll take your questions.
You want to come forward?
Oh, you have to.
Would you introduce yourself?
I did bring a report, and it does start with page 2. There's not a page 2. That's actually page 1. The other one was a cover page, but we was in a hurry to get over here. We just got back from a meeting, and Jamie is in a meeting right now, so I brought these over, and if you have any questions, I'll be glad to take those back, and we'll get answers back for you.
Well, I'm sorry, what was your name?
I'm sorry, I'm Deborah Wilson. I'm the administrative officer in the Gaming Commission.
Well, I'm glad to have you. You're much better looking than Gaming.
I won't tell him that, but he won't. I always tell him his age before the meeting because I'm older, much older than he is.
And you have any questions according to the gaming report? Thank you for bringing those. Oh, I'm sorry, Mr. Garvin.
Tell the Gaming Commission the council feels like they're doing a great job and keep up the good work.
Well, thank you. I appreciate that.
Thank you very much. Thanks for bringing that over. Mr. Hembry, classification.
We are finished with Volume 1. We are halfway finished with Volume 2. I hope to have been finished by this month, but it will be next month before we are finished. I'm going to, I plan on meeting with Mr. Morton, I think, on Monday, and he's going to give me a further report on their end of it. But it's going very well, and we're almost there.
If you want to briefly say anything about the court rules?
Oh, the justices were very proficient in getting their new court rules over. Not any really major changes, but they are complete, and that takes, that's several pages of work in and of itself that has been done. So, yeah, the court rules are complete, and that was done by Chief Justice Matlock. So he should be commended on that.
Any questions from Todd? Okay, thank you, Todd. Ms. Hammond, so is there anything to report on GEG?
I don't have anything new this month at all.
Anyone have any questions for Diane on GEG? Good deal, thanks. Ms. Raymond, Cherokee Nation Education Corporation.
I'm not Ms. Raymond, but I'm Shelley Allen.
We'll listen to you.
I think Ms. Raymond reported out to you all a couple of months ago. She is our development director, or holds a position as development director, and I'm the secretary treasurer for the Cherokee Nation Corporation. And I've held that position for a number of years. So with that, I've submitted my quarterly report, and to my understanding, that's how frequently I come before the Rules Committee to report out on the corporation news. Is that correct?
Yes. Now, would it be more appropriate to the Rules Committee if she reported, so she doesn't have to report twice, to the Education Committee? Does anyone have a problem with that? Yeah. Ms. Jordan?
We went to the annual meeting, and in fact, there was several of us there.
Yes, thank you.
At their annual meeting, and their board's specific preference was to ask that they be brought in front of this committee.
And the rules? Okay. I guess that answers it then.
Good. So, in addition to the quarterly report that I submitted, and you all have, we did have thank you all, those of you that attended the annual and our regular board meetings. We have a newly elected slate of officers, and as maybe you are aware or not aware, Brad Carson was our president and held that position for a couple of years. And of course, he was called to active duty and resigned his position there. And so at our annual meeting, we elected, we have a newly elected president of the board, and I'd like to just throw her name out there for you all to hear for the first time as president of the board. Her name is Kimberly Gilliland, and she was just nominated and approved through our council process in December. And so she was surprised when I nominated her for the presidency, but she has all of the qualifications that it takes to run the corporation. So we're very, very pleased with that. And I also said that I think the last time Margaret Raymond reported out, the first and last time she reported out, we have our Cherokee Nation Education Scholarship applications. They are worldwide distributed, I guess, because they are on the internet. They're on our website, and you can pull them off of our www.cherokee.org. And I have packaged 8 applications for each of the counselors here. And on the back page, or the back side of the application, you will see the number of scholarships, the designated scholarships that are available. That I've highlighted myself before the meeting: the Cherokee Nation Education Mission Award, the John Shure Journalism Award, the Nell Brown Memorial Award, and the Tribal Council at-large Scholarship Award are the ones that more than likely you all would focus on and distribute and talk about with your constituents and your communities. So, and I've gotten back a few scholarship applications, but March the 20th is the deadline for scholarship submittals. So, with that, are there any questions?
Questions? Ms. Allen? Oh, Mr.
I
President.
have one. Shelley, and you probably know the answer to this too, but on these scholarships, do you have counselors, or do you have anybody go to school and talk to the students there in the high school about these scholarships? Or how are we getting the word out to the kids?
We're getting the word out through the internet, and in particular, I send out to all of our JOM schools the application to the superintendents and to the JOM contacts. Yeah. And there's one scholarship, designated scholarship, specifically focusing in on our JOM students, and that's the Red Clay Award. But the one-stop application goes to all of our schools.
It's just, I talked about Autumn J, and I just, we don't have a counselor up there at J that concentrates on our English students, and I'm just wondering, I don't think that really gets out to the kids. They just say, here, look at this, and, being a kid, you don't pay a whole lot of attention to it. I just feel like at some point in time, we need to have a counselor, just a circuit rider, just go around and talk about scholarships.
Now, our higher education program is really making an attempt to go out to the schools and to go to the community meetings and be able to disseminate not only the Cherokee Nation scholarships and applications, we've given them our applications also as well. We have an announcement, a real nice little announcement in the Phoenix this month. It goes, this is in my report, that we've advertised in Indian Country Today and the Tribal College Journal. So it's really going out to a real broad-based spectrum of people. So, but you're right, and that's. I wish the counselors would really, whether they be the Indian counselor or the non-Indian counselor, I really wish they would focus in on scholarship application preparation. I know that at Sequoia High School they do a bang-up job with that.
Yeah,
they do that, yeah, and we can see the results of that work initiative. So.
Thank you.
Ms. Fishing Hawk, and then Mr. Garvin.
Monday in Adair County, we're bringing higher education over there to do a workshop application with the students and the students. Do you want to bring anybody, or will higher education make yours explain it? Or?
Higher education will, or I don't know, when is the date of that?
Monday.
Monday.
You want to come over, the bunch of the crews come over and come over.
hold a workshop in our county to show all the high schools how to fill out applications and what's required and dates. And it's Monday night at Marietta School at 6.
Okay, if I cannot go to that, I will make sure that Jan Grogan knows and has ample documents to pass out. But they can be accessed, as our Cherokee Nation can too, but they can be accessed off the internet.
Well, if
So,
you can, could you try to get somebody there for
okay. We don't have a staff, so it's either me or me or me.
Oh, okay.
So,
Mr. Garvin and then Mr. Hoskins.
Dr. Allen, is this for all citizens or this local, does this go USA or?
the scholarships that go out there, beyond the jurisdictional boundaries, is the at-large tribal council award. As you can see.
Which one is that?
Let me show you. On the back of your application are the designated scholarships and the criteria associated with each one of the scholarships. And it's here. Now, the John Scher Journalism Award will go out beyond the 14-county area, as well as the Cherokee CNEC Mission Award and the Nell Brown Memorial Award. But specific to each of these scholarships, they have to be Cherokee citizens. They have a citizenship card. Does that answer your question?
Yes.
Okay, good. Is there someone else?
Yes, Mr. Hoskins.
Thank you, Madam Speaker. I have a suggestion. I'd like to see on future applications in pretty bold print that Cherokee Nation Education Corporation is a different entity than Cherokee Nation. Cherokee Nation Higher Education also provides scholarships. Please visit their website, something like that.
Oh.
I only have anecdotal evidence of this, but I know of one constituent who got mixed up, and it might also do some good cross outreach if both sides are advertising for the other. Then secondly, I think it's wonderful you have the Tribal Council Award. I always thought it was called the At-Large Tribal Council Award, and it's a little...
It is.
Maybe
And maybe that might have been a mistake that we left out at large.
We want to give the at-large councilors credit.
You bet. Yeah, because of Julia and Jack Baker's efforts and submission of this little discretionary monies for the at-large scholarships. We are really appreciative of that.
Thank you, Madam.
Any other questions, comments?
Thank you all.
Thank you, Ms.
Thank you for
Allen.
your interest.
The next order of business is old business, and item 1 under old business is mortgage foreclosures. You have that there, Ms. Jordan.
Is Diane still here, or is she the one thing for Harley's request that we were going to ask to be added to that report was the date of the sheriff's sale. And that hadn't gotten put on there yet.
If you don't mind, I can address that. We are actually, Commerce is working with the Attorney General's office to prepare a more comprehensive foreclosure report. I actually have a sample of it here. We didn't distribute it to you this month because it's not fully complete. I mean, I can send it to you if you guys want to pass it around and take a look at it. But that is something that'll be added. We've added some sections for what the foreclosure date is, the appraised value of the property, how much the first mortgage is, how much the second mortgage is, and the types of housing services that those particular structures receive. I would expect that by the end of next week, we'll have the entire spreadsheet complete. At this point, all we're looking for is the structure type. We wanted to indicate whether they were mobiles or stick-built homes. But by the end of the next week, we should have all of that complete. If you'd like me to pass this around, I'd be glad to.
If we're revamping the form, when it does get to a sheriff's date, if you could give us some kind of location, how we might find this home. The reason we're interested, and I think from Harley's standpoint and my standpoint, is there's some money maybe to repurchase these homes and put them back into our inventory to go out to another family. And so we want to keep close tabs on the sales.
Okay, so you want more than county, you want an actual property address?
I think it would,
Like a legal description or just
Well,
a
legal
site
description
address?
won't help you find anything unless you got a plat book. I have plat books on all the counties, but they really need the physical address.
It's on maybe the general direction of where it is.
We can do that.
So not too long.
I know that's going to be kind of cumbersome, I'm not real sure.
Probably, if you wouldn't mind, rather than including all of the addresses every month, what we would probably do is the ones that are coming up for foreclosure in the next month or two, send those as a separate attachment.
I think that would be
At this point,
appreciated.
it's a pretty big, full, full page as it is, so if we could attach that as a separate page.
That would be good.
And what might work on that, Shay, it may be a little bit better, is maybe just a community name. I think we're all familiar enough with communities that where we could identify it's close enough to being to the community. So that would eliminate legal description, land descriptions, things like that. If you just had a community name like Fall City. I mean, you kind of know where that is. So that would eliminate some paperwork there too. The other question I have, Madam Chair, is some of these are dated back in the '01. Have they already been sold today, or do you know?
You know, Harley, I don't know the answer to that. Do you know if all of these that received assistance in '01 have those gone to sale yet?
You want to come forward so we can hear you?
Hi, my name is Danita Cox. I'm at the Attorney General's office. We have a list of a few that have already been sold. Most of these are the mortgage assistant program, so we had the second mortgage on that. We have Crawford, if you have your list, that has already been sold. Goss has been sold. Ross has been sold. Glad, Harris, Miller, and Smith have already been sold. I have a list of them that are coming up for foreclosures, if you want those. Shote, sheriff's sale is going to be February the 12th. Davis, the sheriff's sale is going to be February the 17th. Soap, sheriff's sale is going to be February the 25th. Tanner, sheriff's sale is going to be February the 17th. And there's one that is not on the list that just came to our attention. We didn't have the files. Don Baker's office had the file previously. We just got notice of a sheriff's sale, and it's Vicki Mason, and it's March the 23rd. So we have about 5 or 6 that are getting ready to come up for sheriff's sale.
What counties are those in?
I don't have the counties on me. I just have the list, but I can. I have these all scanned in, and I can email them to whoever.
Just
you would
email
like
them
them.
to Kelly and she can distribute.
Okay. Okay.
Thank you.
Is that it?
Mr. Baker?
No. A couple of questions. One, the ones that have already sold, how are we coming out on our second mortgage?
It's usually the first mortgage company that's been buying them out for the total amount, so we can try to come back and try to sue to try to get our mortgage out of it, but usually the first mortgage companies do show up, the banks, and they get the $40,000, $50,000 after it's been appraised. They usually,
Pretty much they just close us out of it.
yes.
And I think what Tanya was talking about was maybe looking at it and see if it was worth taking it up, another 1,000 or 2 above what the bank, so that we get the property, even though we could get it for probably $100 over what the bank is owed against it, if it was worth fixing up and selling to where we should get our $15,000 back on top of it. I think was part of what she was thinking. So pretty much we're just going and seeing our $15,000 go down to.
Yes.
Right. Got a second question, and I don't know who can answer it, but I see here that there is a foreclosure on rehab work for $32,000, and it's the deed is in restriction. Since when did we have to get a first mortgage to rehab?
I believe she probably took out like a second mortgage on that. And
I'm
the
just,
rehab, some of them have been going to bankruptcy, and they go ahead and they sign a reformation agreement and pay it back. But on that particular case, I don't know too much about it, but we did file our answer and cross petition, and so far we're just waiting for a journal entry of judgment on that case to see if.
So, do they owe the 30-some thousand to somebody else?
No, they owe it to us, but it also depends on how much work that she actually put in on doing the home, is how much it's owed. From what I was told, however much work that she put into the house.
I'm so confused.
That one is a little bit.
We've rehabbed all over the country, and I don't understand there's no repayback. There's no payback on rehab. Yes, please.
I just wanted to say, I believe that they're putting a deed restriction on those properties as part of the useful life. For Nahazda, I think they file a deed restriction for a certain amount of time, and at some point, whatever the investment in the property is, they are filing a 15-year deed restriction. Once the client has lived in that home for 15 years as their primary residence, that deed restriction would be lifted.
Why are we foreclosing on it, is my question.
I don't know the particulars of this case, but I would assume that this client either already had an existing mortgage, or after we had done rehab, they went out and did some type of mortgage against the home, use the home as collateral for something. I don't know the details of it. I can do a little bit of research and try to find out. But
well, I mean, just from what I'm reading, it says that it wasn't a MAP, it wasn't anything, it's rehab.
Right.
And there's nothing owed to the nation on the second mortgage other than a restricted deed.
Right.
So, I mean, if it's a mortgage company, that's something altogether different. But I'm just curious.
I'm not certain, but that's what I would think, that they either had an existing mortgage when the rehab was done, or after the rehab was performed, they went out and used the home as collateral for something else.
Thank you.
Don't leave yet.
Just a comment. We used to see those at the Housing Authority. We go in and do the rehab work, then they go out to, there's a place over at Muskogee they can go to and get a $10,000 mortgage. And then they don't pay. So your second mortgage holder is actually the one foreclosing. And now you're trying to defend on your first mortgage. They're banking on the fact that this home may be worth, if they've got a $10,000 mortgage, it's worth $50,000. So we would get our money back, then they get their money. They're actually doing the work for us.
Okay. So our deed restriction is virtually a first mortgage.
Until it falls off, there it is. I mean, it's kind of considered as one.
There's no dollar amount associated with it, but yes, like Tanya said, until the useful life has expired, then yes, we have an interest in that property.
Okay. If you could research.
Sure.
Thank you. Next item under old business is constitutional amendments covering term limits. Says discussion only. Ms. Townwatt, Mr. England, and Ms. Fulbright.
Madam Speaker, first I think Dr. Coates is still on the call. I would like to add Dr. Coates as a sponsor. She requested that by email this morning. Is that still the case, Julia?
Yes.
Okay. And then I would like to amend the agenda to actually take action on this today.
Have a second?
Second.
There's a second. Any discussion on amending the agenda to take action? Possible action? All in favor? Mr. Baker?
I guess I would like to discuss it first before we amend the agenda to take action on it, but I'm just going to vote. Thank you.
All in favor of amending the agenda as stated, signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Okay, we will amend the agenda. Ms. Townwatt.
Thank you. Madam Speaker, I think Mr. Hembry is prepared to split the language so that it would be 2 questions on the regular election in 2011, so there would be no additional cost to the Cherokee people. It would be 2 questions on the ballot, and it would be the question of term limits for the legislative branch and the question of term limits for the executive branch. And I would like to move to approve so that we can begin discussion.
Second.
All in favor, any discussion? Any discussion? Mr. Baker and then Mr. Hoskin.
Yes. You're breaking it down into 2 different items, but there's a third item, providing for a large statements, another opportunity. So should that be a third? So bring to a third?
Ms. Calmar?
I will accept that if there's 3 questions on the ballot that we presented to the Cherokee people in the regular 2011 election.
Mr. Baker, would you restate that third?
Yes, where it says that all registered voters residing outside the boundaries of the Cherokee Nation may at the time of the first election to fill at large seats choose to continue to be registered to vote in the district which they were previously registered. So we're changing that to not just the first election, but at the 2013 election, they will also have an opportunity to decide whether they want to go back to the district they were in or choose the at-large.
All minds really clear? Ms. Jordan?
No, my mind's not clear. I just want to make sure that none of this is coming up for a vote till 2011.
Absolutely,
None
2011.
of the 3 questions. We're not going to have a $250,000 election in between.
I do not think that it is necessary. Personally, I don't feel like it's necessary. I think it's appropriate in the 2011 or regular election that this needs to be answered, and that's what my constituents have asked.
Dividing it into 3 questions, so they'll have 3, they can vote 3 different ways if they want to.
Well, they can vote yes or no on 3 different questions. Term limits for legislative branch, term limits for executive branch, and the opportunity for another one-time decision on whether to go at large to vote or not as constituents.
Okay, so the pot would be set for the next time that we've already got the folks where they're supposed to be.
Yeah, there's nothing retroactive. It would only then affect whatever their decision. If it changed the current circumstances, it would only affect the following election after the regular 2011 election, whether that be a regular election 2 years following or what we normally would see 4 years after, or a special election. But it would not affect anything at the 2011 election.
Any other questions, Mrs. Arvin?
I really don't think this is needed because out of the class of 99, Councilman Thornton and I are only 2 still standing, and the Cherokees really turn them over pretty fast. So if you're sitting here now, you may not be 4 years from now. Anyway, I'm going to vote for it. It's a good idea.
Further discussion? Dr. Cobb and then Mr. Haas.
I just want to make sure on this.
I'm
sorry.
Okay.
No, I mean, you're first. Go ahead. I have no problem. As long as I'm still in the queue, I'm going
Well,
Sorry.
we're gonna approve one resolution that's gonna result in 3 ballot choices. Is that right? We're not going to take each of these in turn. Is that my understanding? Maybe that's a point of clarification.
One resolution.
And then secondly, I guess walk me through it. If this is approved in 2011, this will apply to all. Obviously, people will be elected new. Some people will be elected new in 2011. Some people will be sitting members of council. How will that? Maybe Todd could address it, or maybe Councilor Cohen Watts could address it. How will that affect those that are currently seated on the council? Will we have been elected the first time under term limits? I mean,
Mr. Embry, you want to respond?
That's a pretty tough question, off the cuff here. Are you saying that? Well, first let me say this. I think we should add a resolve clause in here that be further resolved that the said ballot measures will be or shall be conducted on the general election of 2011. So there's no doubt as to when the ballot measures will be taken up. Now, Mr. Councilperson Hoskins, you're asking that. Restate your question.
Yeah, I guess. Such a good question. I can't even remember. But no. I guess if you're a sitting council member 2011, you're not up for election, you were elected under term limits. I guess as a practical matter, if term limits are removed, you've still only got one term under your belt. The next term comes up, you're operating under no term limits under this new amendment, so.
Right. What would happen would be at the general election of 2011, which would take place, I'm going to say, assuming in June of 2011. These three ballot measures would be on it. Okay. If they pass after that election is certified, that no longer is part of the Cherokee Constitution. Okay. So there would be no term limit restrictions.
And then, I mean, I'm in favor of actually us voting this three separate motions, in part because I sort of favor the U.S. way of doing it. Term limits on the top and no term limits on the legislative branch, with all due respect to the chief. I think it's been an appropriate way to balance the power at the federal level, so I've got a philosophical opposition to term limits, and always have and probably always will, but I think, in terms of legislative office. So, I mean, I don't know if I can support this unless we split it, because I don't think I'd support it on the cheap.
Ms. Calmwatts, no, Dr. Cobb, then Ms. Calmwatts, and then Mr. Thornton.
If you can hold your train of thought, the third part of this is something that Councilor Angle and I have been talking about quite a bit. I just want to make sure exactly what that third component says about whether you can pick. Is it an age limit? Is it basically if you live at large? I just want to be clear when we vote on this. If you live at large, do you have the choice? If this passes in 2011, if the people vote that in, if you live at large, irregardless of age, as the only requirement is you're at large, do you get a one-time shot to pick where you want to? That's what I'm asking.
Yes.
I want to be clear on that.
What happened, if this were to pass in 2011, we changed basically just changed one word in what is the current Constitution, which says currently it says at the first election to fill out large seats. Okay, we just simply strike the word first, and then put in, at the time of the 2013 election to fill at-large council seats, you get this one-time shot. So if it passes, those people would have 2 years to decide whether they would get another shot, but they wouldn't get that shot prior to 2000.
Correct. And if I may, this may not be the place to put this wording in here, but one of my big problems with the way it was done before, it was done too quickly. You had we got the forms and it was due in 4 or 5 weeks. Is there any way, I guess I'm exploring the question. They got 2 years, but that's great. If the forms are sent out to them 6 weeks before it's due, it doesn't make any difference. I guess that's what I'm asking.
Well, that basically would be a question for the council to just run roughshod over the election commission to make sure those, that's done.
I'm sure the election commission loves you. Okay. That answers my question.
Well, let me rephrase run roughshod. Unless they strongly encourage them to get that.
The motion before us is, do we approve to amend this resolution, or whatever it's going to be, to include these 3 items, right? That's clear on what we're discussing here? Okay. Ms. Calmwatts?
Thank you. So back to Mr. Hoskins, Councilman Hoskins. So the way I understand it is, I have been seated not as long as either Dawn or David, but I would be under a term limit. So we don't know what the court's decision is. I personally do not believe in term limits. Philosophically, for us or any other body, I think it's up to the people to decide those things. But regardless, we don't know what the court's decision would be regarding those who've already served 8 years or 2 terms. So this has no effect on me. If the courts come back, for example, on me and say that we have been under those term limits since that first election, that when I was elected, then I would not be eligible for the 2011 election. But the people absolutely, I believe, have the right to determine this separately, and that's what they've said, because we had the all or nothing decision on the Constitution. They would like this brought back up to decide. What I would ask is, even if you don't personally, which I'll tell you how I'll vote at the polls, I probably will also not be voting to exclude the executive term limits, because I think the U.S. model does work really well in that sense. But I absolutely believe it is the right of the people to decide that, and not this body. So even though I have split those two so that they can be considered separately by the Cherokee people, I'd ask you to really consider allowing the Cherokee people to vote on that issue. And not just because you don't believe that the chiefs and the deputy chief should be limited to 2 terms. I think that's out to us to go dialogue on the issue in the next 2 years before the election. But it should absolutely be the people's right. And if this body feels strongly that these need to be 3 separate resolutions in order to make it clearer on the legislation that's coming forth from our body, I would entertain a motion to do that, or a friendly amendment, if that is really what we need to do to make it clearer for the Cherokee people. Thank you, Madam Speaker.
Mr. Thornton?
Care to run over something there? Todd?
Sorry, listening to a phone message. Yes.
Games?
Yeah, playing Tetris.
Care to run over something there that I was going to answer. If our courts decide that we're in our 2nd term limit and we can't run again, in 2011 we can't file, right? Whether this is on the question or isn't on the question, we won't be able to run if we've been there 2 terms.
If the Supreme Court would so rule, yes, that is correct.
Okay, that's all I want to know. Thank you.
John?
Yeah, I would make that motion friendly or otherwise to divide these 3 questions separately.
Do I have a second?
Well, I'll accept it as a friendly amendment, and that'll be presented at the, so if my second, who seconded it?
Yeah, I did.
Okay. I don't have an issue with that.
Okay. Ms. Fisher-Hawk?
That's what I was wanting to get at, the all or nothing. I felt like we was at filling in, just, I'd rather have it separated.
Ms. Jordan?
That was what I was going to ask, if she would accept a friendly amendment.
Mr. Baker?
Back to the at-large. The way this is worded, all registered voters residing outside the boundaries who at the time of the 2013 election to fill at-large council seats choose to continue to be registered to vote in the district in which they were previously registered. Well, at that time, everyone previously registered would be registered at large. So you're going to have to go to say previous to the implementation of the new Constitution. Is that correct? Because the previous registration is going to be already going to be at large. And they can't go back to a district and choose a district of information.
Are you asking Todd a question?
Yeah, and I'm thinking.
It's on the clock.
Yeah, that's what I'm saying. So, prior to implementation, to say that they made all registered voters residing outside the boundaries of the Cherokee Nation may, at the time of the 2013 election, to fill at-large seats, shall make an election to choose to, and then I have to work on this wording, but, shall make an election whether to choose a district within the jurisdiction. So, that I could have that ready by full council. And I'll work with Diane on it.
Mr. Telephone Maker?
Yes. Two thoughts. One, do we really want to, they're going to vote in the 2011 election as at-large if they hadn't already switched over. Then we're going to open it up again for one whole nother deal of confusion. And true, some people were upset that they didn't do their part, and, or they didn't know it, or whatever. But, you know, now we're 10 years down the road, and we're opening up a can of worms one more time. And I think you're just, you know, keeping the election process in turmoil. If you know, they were told one shot, one time, and the Constitutional Convention was pretty explicit about just a one-time deal. You know, let's give them one opportunity, and if they really want to vote in those districts, then they'll do what, you know, they'll do their part. Well, some did. But I don't care what you do, some aren't going to get it done. And, you know, that bite at the apple, bite at the apple, bite at the apple, I think it just keeps the election commission and the election process and everything in turmoil. But, that being said, and let's think about it, but I would really make a motion to table this until Todd gets all the writing where everybody can read exactly what's going to go on the ballot. This isn't a permanent table or anything. It just, I would truly like to read exactly what's going on the ballot before I vote to put anything on the ballot.
Second, with a friendly clarification amendment that is to the next rules meeting.
Absolutely.
All three.
Yeah, and that'll give him time to get them worded where they say what you're intending them to say, and then if we don't think that's what it says, we can talk about it.
And we have a motion to table and a second. All in favor, signify by saying aye.
Aye.
All opposed, same sign.
And point of information that is all three will be on the agenda separately, and Todd will have those, right?
Yes.
Okay, thank you.
And just a point of clarification, we will add the paragraph that says it would be voted on in 2011, and they're gonna change this other paragraph that Jack
I think that's
pointed out.
Todd.
And I will bring forward 3 separate resolutions.
You do that. Okay, next is item 3, travel local mileage policy. Todd researched the law on this, and you do have a revised or an amended policy in front of you. It's separate, not the one in the book, but it's separate. And also the legislative act covering the travel policies, travel expenses. So the reason I brought this forward is twofold. One is to implement the legislation. Secondly is to clarify some confusion that seems to exist among some of us. As you can see there, the Travel Council travel is governed by Legislative Act 2399. And it reads that it's covering reimbursement of travel expenses in addition to the compensation a Travel Council member receives. They shall receive reimbursement for mileage only for attending council sessions or official Cherokee tribal meetings called by the council or administration. Accordingly, a few of us are not in compliance with this legislation, and we're listing mileage within our respective districts, which does not agree with the law. Additionally, past practice has been that council members are limited to 3 trips outside the Cherokee Nation jurisdiction for training or other Cherokee Nation business. And there was no written policy. You know, if someone said, well, I heard you do it this way, I heard you do it that way. So this policy is written in that spirit. Since we're responsible for financial oversight of the Cherokee people's money, and due to the fact that as Speaker, I'm ultimately responsible for the Tribal Council budget as it relates to travel, I cannot and I will not approve mileage or travel that is not in compliance with the law. Now, that being said, if you don't agree with it and you want to change it, I suggest you give it Todd and rewrite or amend the legislation. And then we'll implement a policy to comply with the amended legislation. But as it is, this policy before you is in compliance, I feel, is in compliance with Legislative Act 2399. Mr. Hoskins.
Is this legislation that we're voting on, or is this a policy you've implemented
No,
in your advisory?
the policy I'm implementing,
Do we have the underlying legislative act?
yes, it's there.
Handed it?
Mhm. It's quite, let's say that $23.99.
Is it in the packet or was it packet?
It's handed out, separate.
Could you, obviously, we can all read, compare it with what our understanding was. Could you sort of walk us through the significant changes that this might make from, well, I don't know if this is a change at all, but I mean, in terms of things that were out of compliance, is it simply the in-district travel, or are there other things that are changed by this policy?
The two major violations, I guess you could call it, are charging for in-district mileage, and I think some of the new people didn't know this, but we're allowed 3 trips, and that's what I was told last term. We're allowed 3 trips per year, and some of us have violated that. So those are the two major. And I also asked Doug to do a 5-year history of the tribal council budget. And for instance, from 2007 to 2008, the travel has almost doubled from 46,000 to 91,000. That's 2007 to 2008. And January 1 through January 28, our travel expenses already $32,884. So with our budget being for travel $130,000 at that rate, we're going to go over our budget in just 3 or 4 months. So, and that's another reason, Mr. Hopkins, is we're kind of getting ready to exceed our budget.
And I'm sorry for the paper shuffle here, but I'm trying to, is it Legislative Act 2399? That's the legal authority for...
That's correct. And Todd did research that.
And this is what restricts us not to claim in district, is that correct? I've not claimed in district and thought we never thought we could, but I'm curious as to what specifically prohibits it.
Yes, that law, spells out what you can get mileage for. And there's 2 things, council meetings or meetings called by the administration, and that would be, if you're on a C&E board or C&I board, that's a council meeting. Because you're part of, the ex officio advisory board. I guess to answer your question, I think that's the authority.
This document, 23-99, is that what we're talking about?
Might be in cross-examination. Yes.
I just want to make sure I see it right now.
Yeah. Well, let me, I can't see that far, but I believe that's...
Okay. And then there's a section in here about continental United States. I think there has been travel outside the continental United States in the last year, so that's prohibited under this policy.
Under this policy.
And is that based on just a policy judgment or based on any sort of underlying rules and regs that...
Well, what I'm looking at it from a financial standpoint, if we're already 32,000 as of January 28 into our travel budget of 130,000, we're going to exceed that in 3 or 4 months. And Ms. Dr. Cobb.
Can I ask, on this reasonable, it's number 3 at the bottom of page 1, a reasonable period of time. I guess the easiest way to put this is, what's convenient for the staff and for you to turn in mileage? Because I'm pretty much doing it about every 6 months.
This is on advice of the staff. They recommended 30 days.
Every 30 days?
Mm-hmm.
Okay.
And make sure that your expense reports are complete, because some of the council have been getting them back because they didn't have a starting point or they didn't have mileage or whatever. Make sure those complete, because they want to approve them over there. Mr. Baker and then Mr. Anglin.
Okay. So for the ones that are the at-large, this is Julia and I, We have several community meetings that we attend each year, such as Houston, probably 2 different trips, but
Those are all
4 different places, which you're right.
Did you call it or did administration call it?
Well, the communities call them. So we're probably going to be attending 4 or 5 or 6 at least each year for those. And they are within our district. So we'd be excluded from mileage, but the travel, I'm looking at the 3 trips outside of the Cherokee Nation jurisdiction. But that would be limited to the at-large also. And then the other, where it says the tribal council meetings only for mileage, what about if we're on the advisory board, say of C&E?
That's included.
Yeah, that's an official meeting of the tribal council if you're on advisory.
But it's in my district.
You don't get paid for it. No, but no, even if it's in your district, if that's an official meeting of the Cherokee Nation, which your advisory board would be, you get mileage for it, okay? Same way with Mr. Baker. He lives in district. He could get mileage for, coming to council meetings.
So my concern is the limit of 3 trips for the at-large counselors.
Well, you're head of executive finance, you might want to look at the budget.
Okay.
Ms. Jordan? Oh, you're down after Ms. Jordan.
I'm curious, was that $32,844, is that mileage?
That's travel expense.
And who got my $2,000? Because I didn't get any of it.
Doug, you may want to address that.
It's under the travel category. It won't be mileage. The travel expenses is under category of transportation. They segregate mileage from travel so we can see overnight stay travel compared to conducting ordinary business mileage reimbursement.
All kidding aside, if I still have the floor, at this rate, we need a budget of $400,000, folks. And that seems a little extreme in light of the fact that we got people coming to us that don't have money to go to school, don't have money for housing, don't have money for health. We could rein it in a little bit without probably hurting anyone to a certain degree.
Is that Ms. Jordan? Yeah. Ms. Fishing Hawk?
That's what I was
And Mr.
asking.
England.
I was just going to ask about the $33,000 a month.
Okay. Mr. England?
Thank you, Madam Chair. Since this act was enacted in '99, I think our whole districts have changed dramatically compared to what they used to be. Brad and I, we attend 3 meetings every month that our communities call, and the administration has staff at every one of them meetings every month. And we feel like we're obligated to be there because the administration's got people coming to these community meetings that they call. And I can guarantee you, I can look back through these names that voted on this, and these meetings wasn't happening back in '99. And so I think our whole thing has changed, and I don't think it's fair that we didn't have that large counselors back then, and I believe that if we stay on track with this here act here, I don't see where Julian and Jack is going to be able to move. I mean, they're going to be hamstrung. So I think we just got to look at doing something different. Because I think everybody in these rooms are attending community meetings every month. I mean, as far as I know, and I guarantee you it didn't happen back in '99. So that's just my say. So.
Mr. Soap?
Yeah, I think that you have to be careful about just picking out, 1 month and saying this is what the expected travel budget's going to be for the remainder of the year. Do you know offhand, Doug, how we ended up in '08? Were we close to the budgeted allocation, or were we over significantly, and if so, by how much?
Our '07, we had around 38,000 budget, we spent 40, so we were real close. And that year, I did a reallocation close to the end of the year to line up and utilize funds that from vacant positions and things to lined it up. Same thing in 2008, except it was a $60,000 budget. We spent $62,500, so, it was close because of the realignment. It's an $80,000 budget for this year, and I agree with you. Look at 1 month, and it's really hard to get a good projection for the whole year, especially, if you hit a high meeting month that has a lot of activities. But we are, and I'll make this statement if I may. I can manage our budget within whatever the wishes of you guys are. I'll manage within this budget, and I'll make sure that I won't come to you for additional funds unless it's absolutely necessary. But without a clear directive against an historical increase, trend, that's what the concern was. I can add money to this line item if need be, at the expense of some of the other initiatives in our budget that were intended for contract services or vacant positions.
Yeah, I think that it's interesting to hear that there is a trend occurring of approximately 20 grand per year over the last couple of years. And would it be better from an accounting standpoint if you had a certain allocation versus a 3-trip type designation? If I'm going to New York City, Tacoma, Washington, and then Hawaii, or I guess you said we had to be in the continental U.S., so, Montana or something, then that's a lot different than going over here to Little Rock or, Houston or something like that, so.
It would be easier to budget if it was a flat amount per person, but that would put some obvious strings on you guys to try to anticipate what your travel costs are going to be.
Okay, all right,
And it might be rougher on y'all.
Yeah, and of course, Chris hit it on the head. We've had a joint council meeting and the inauguration, which are two extraordinary situations that are extremely important. So, it's going to skew travel on the front end of this budget. And, I'm not for allocating so much per individual because there's some of us that haven't traveled for years other than those meetings. And then others need, have purposes that, they need to go. But I sure want to guard against restricting travel when it's important. And quite frankly, leaving Hawaii out is kind of a bad thing, simply because, and I'm not going, but I do think some people need to go because we're going to be in crisis with our language. We've got immersion, but they've got the premier program of immersion over in Hawaii right now. And I can see where, we have no Cherokee speakers on the council now, but I really think some of our staff and maybe a representative or two of the council need to go over there and study that a little bit so that we can maybe help implement to do our job. And like I say, it ain't me, but I'm not so sure, the speaker and maybe the chairman of education or somebody really doesn't need to go over there and look at their program and take enough time to glean what they're doing right. Because folks, we're not out of the woods on our language by any form or fashion. So, and I have gone to Alaska before, not on the Cherokee Nation dime, but there's a lot to learn up there from the native government. So, but I applaud Meredith on making a policy, but maybe it does need to be tweaked a little bit from a standpoint of travel. But I really think our travel is going to kind of level out now that these two expensive. Now we've got Red Clay coming out. So this is an extraordinary year. It really is. We have Red Clay coming out, but it's going to be another meeting that I want to encourage everybody to try to go to. But anyway, thank you.
Ms. Camelot? Thank you, Madam Speaker.
First of all, I just want to applaud you and the staff for put effort into this, because this has been a long time coming. As a corporate engineer, I was frustrated from the get-go when I was verbally told our policies on the council. And to my knowledge, I've always followed the verbal directive. And at different times, there's been different people say different things, and I know we've struggled with that, and thus we've got our written policy now, and I'm excited. I do think there are some things that I will be advocating for us to reconsider, but I do want some clarification, and I'll of course work with folks behind the scenes to bring something as a package forward at the next meeting. So I hope this will be on the agenda at the next meeting, because I think it'll be. But I have some questions, because I wanted to clarify. Was your intent, like if I'm on formal boards, like the advisory board, and we meet at Catoosa rather than West Salem Springs or somewhere else, would that not be considered official business under this? Would we need to look at the language differently?
Now, explain that, which
Like
board?
if we meet, so the Cassini Advisory Board.
Okay, and what
So
else?
I consider that official, we'll just use that as an example, so I consider that an official business, but if I read the second last one, it would be excluded because it's in my district. Was that, do we need to address that language if I would want it changed, or is that the way it's interpreted right now?
You can make any suggestions you want, and just get with Todd to do that. But Mr. Hembry, did you want to respond?
Well, and
to what she
I'll
said?
work with him to see if that's, but there's two other clarifications that I didn't know, and this is just initial first blush. There is, what about if you're on boards, like I'm on the Claremore Indian Hospital Board, and I chair that on behalf of the tribe as the tribal representative. Now, the administration had to appoint me, because they're given that. So does that, am I on there as a council person of the tribe, or then am I on there as administration and they've got
What
to
was
pay
your
out?
understanding when they asked you to do it?
It's always come out of the tribal council budget, so I don't know.
Melanie, what was your understanding when she was appointed? As a council representative, or?
Typically, they're elected officials that sit on those.
So did you budget for her travels for those things?
Especially budget for the
Mr. Hembry, you keep pointing your finger up there.
Well, and like I said, we'll come back with it. I guess to address, and this would be my first blush. I think as to the advisory board, you were appointed by this body to be on there. I think
So
that's definitely official business. I think my initial opinion is that if the chief has appointed you to any board, you need to charge him mileage. Okay.
So, yeah, because there's numerous things on the water issue, which I've been helping out because, I mean, just my unique background, and then the staff can only go so far and chief can only go so far. So that would go back to him then. I'll just visit with you guys then about whether or not. Thank you, Madam Speaker.
Mr. Crittenden?
Thank you, Madam Speaker. I guess with a lot of things, there's a paper trail, and we should have some good ones with our mileage vouchers and all. I knew what the policy was last term, I believe, pretty well, as far as travel, and I hope I haven't violated the local travel within district. If I have, I would be willing to reimburse the tribal council budget, just like I would if I got an overage on a travel going to Oklahoma City or Washington, D.C. Is there going to be any research, if you will, or audit type process for any periods of time that's passed?
I don't see it that
to reclaim
way.
some of the people's money in this case that maybe I misspent, or?
I don't see it that way. What I see it is from this point forward. Because some people were told one thing, some people were told another thing.
So I said she'd have to pay it back. She signed
Yeah.
off all of it.
But I haven't charged anything.
Well, I mean, it was good dollars, you know what I mean?
Right.
And if it was not, if I spent money belonging to the people and it wasn't justified,
Sure.
I feel that I should pay it back. That's just my thoughts and my comments. Thank you.
Thank you. Ms. Fisher-Hawk?
Yeah, I have two, three questions. Doug, how much did we budget for red flag for travel?
That,
That didn't come on out.
no, that was
That wasn't $35.
the 35,000. That's the donation that's not.
That's going to have to be absorbed in our budget. Because that came about, the decision to do that came about after the budget was already submitted.
But our part is just 75.
Oh, yeah, I know the donation, but I was wondering about the actual travel, because we was going over these numbers, I knew he was up for 30 and we budgeted for 80.
That's part of the reason why our budget, I increased our travel budget slightly over last year, thinking that we were going to have some joint council this year, not knowing exactly where it was going to be at the time, but, you know, again, I would, as far as the numbers and availability of travel dollars in our budget, and I think the most important thing is a clear understanding of the wishes of the body. And then I can compare that to what's actually in the budget that's being provided for and tell you we're going to be close, we're going to run over, or, you know, I need to do some reallocation.
Okay. My second question is, who's responsible for putting all our travel on the web? Because I've had 2 or 3 questions and it ain't on there from last year, the first year. Who's responsible for putting that on the web? Or maybe they're just not looking in the right place.
The web has on it a link on the legislative branch.
Have you gone to it lately?
I went to it. I don't know where 07 link is. Did you make it?
I did, I called it, I haven't been to it.
Because I've asked this
We're
several
researching
times.
why 07's travel's not on the web. It should be, because we signed off on the spreadsheet, travel spreadsheet months and months ago, back last summer.
And isn't it supposed to be published in
And,
Phoenix too?
Yeah, that is.
Whose responsibility is that?
The accounting department prepares the spreadsheets of all the travel. They send it over here for our branch travel. Gail goes and verifies, yes, this is, or they left something off. Once we all get in agreement that this is the accurate travel cost for this branch of government, and then we give them the okay, they're supposed to put it on the web and give it to the Phoenix.
I think we need to be doing that if we were directed to do that. That kind of bothers me. The other thing is,
I think, Melanie, you have that, done that, haven't you?
We usually,
And we're currently working on 08.
Usually it coincides with the audit, so 08 hasn't been audited yet.
Okay.
okay, the other thing is, as of today, I've got a bunch of community buildings just like Cherokee County does, and I'm supposing Sequoia County's coming. If somebody calls me, want me to attend these like they do, since that is in-district travel, I would be breaking the law, right? Okay, I wanted to make sure that was clear. And the other thing, you know, we was talking about CNI and CNE's advisory board. So like Joe never takes, you never take for going down to CNI, do you, in district?
No.
Because it's just they're right there with you. But like he can start taking it because everybody else is going to, that's living in the same county is taking it.
I think that's what Todd's going to clarify on the policy.
Well, I think if you're appointed by a board, by this council, you know, and whether it's in-district CNI or out-of-district CNE, that's appropriate to charge mileage. If Joe, you know, Joe would be eligible, I would be inviting him to apply for mileage under that legislative act.
Ms. Fisher-Hawk?
Yes, I just want to make sure we get the red plan here and the web.
Okay. Mr. Thornton?
If I remember right, I know I served two terms that I never charged any in the district mileage. This term I had. But if I remember right, we went over this act, and this act has been changed to the fact that they were councilmen that lived in this district, and they collected miles coming to the council meeting, and they wasn't able to before. And if I remember right, Don Crinton was one of those people. Right. And I think there's something somewhere in regards to this about in-district mileage.
Well, that might have been, I mean, and I don't recall it, that might have been a part in a budgetary hearing, but I am not aware of any amendment to that act. in and of itself. See,
There's something there.
okay, and in my recollection of the act itself, when it came to fruition, was that in '99 there was a salary increase of the council that was voted on by the council, and that that was to take care of all compensation. Well, after that passage of that salary increase, there were members that had to travel great distances to council meetings from everywhere, to council meetings. So it was decided, and that's what was the genesis of that act, was that, well, that's a greater burden to the outlying counselors than it was to, let's say, people living in Adair, counselors from Cherokee or Adair County. So the genesis of that act was to say, okay, well, you can charge mileage to council meetings and any meetings called by the administration. And that was the purpose of the act. But I am not aware of any actual amendment or repeal of that act.
Well, and there's another thing on here I'm going to have to disagree with, and that's on these community meetings or any time they have a meeting where the administration shows up. I don't believe you should be charged mileage, or you should be able to charge mileage. I believe you should be able to charge mileage if you go and you're asked to go, because that's a business of all the people in your district. And by the time I go to NICUT, and maybe I'll have someone that wants to talk to me at Roland, or at the Roland Casino, and go by there and get back home, that's 80 miles. I mean, it's 70 coming up here and back. And I don't think it's quite fair. I think the reason I started charging mileage was because this $2.50 gas and $1.90 gas, and I mean, it was getting expensive out of the pocket. And when you go paying $40, $50 for a gas tank, and at that time I was driving a truck and I was paying $80 to $105 for a gas tank. So I'm going to have to disagree with some of y'all on some of this.
We have 10 minutes. And Mr. Soap, Mr. Buzzard, Mr. Baker. Mr. Thornton, are you finished?
I always was told that we had 3 different meetings we could go to outside the district, outside the state. And some of the meetings that we go to outside the state didn't count.
Right.
If we went to a joint council meeting, that didn't count. If we had to go to a national convention meeting, that didn't count. So I think we need to think about that too and put those in there, not just limiting it to 3 meetings. I think, like Mr. Baker said, all these meetings that we're going to, like the Red Earth that's fixing to come up, or what is it being called? Or what are they called? Red Flag. Red Flag, Red Earth, whatever it is. And also these other meetings, like going to Washington, D.C., I don't see anything wrong with that.
You can call and make a suggestion. I mean, as it's
I
written.
think you're going to get some suggestions, Tom.
Mr. Soap.
I yield my time.
Point of order.
Mr. Buzzard.
Point of order, I just want to make sure.
This
We're
isn't
just-
law.
This is the rules from this day forward unless they're
Unless
changed
it's
by this
changed.
council later on. So right now, as of today, when we walk out of here, we can put this in our car, and these are the rules.
Right.
Okay.
But it'll be on next month's agenda if you have revisions or amendments or whatever.
Well, I think if I've got the floor, I'd just like to make some comments. This was passed back in 1999, and I agree with what Councilor Thornton was saying, that gas is $1 a gallon, and now it's $2, and when it's $4 a gallon. The other thing I want to say is, when I took this job, I took it and I knew what it paid, but I took it as a full-time council member also. I don't have a retirement, I don't have another job that I hold, so those gallons of gas going in my car adds up. So yes, there are going to be some things that's going to be said about it. I'm not particularly griping about the policy right now, but I think there's things that fits different people in different areas here. So yes, I think there will be some things added to this that we need to take into consideration. I took this to be a full-time council member job. I don't have a retirement coming in, and I don't have a job that I hold. This is my job, so, I just want to put those comments in for the record. Thank you.
Mr. Baker, you're the last one, though. You have to move on to new business.
Yeah, and just by way of the way we used to do it, if you got an invitation from the Cherokees in Albuquerque to be their speaker or whatever, and we would turn in the invitation and all, and then that was a paid for, an out-of-state trip. But just going to be going, it wasn't. So I guess, if you're invited or you're a speaker or something, that was one of the other rules of thumb that we had back when Gina was doing it. And I don't know what the legislation behind that was or whatever, but if you were invited, it made a difference somehow. So maybe
Mayor, Red Clay wouldn't be counted anyway because it's both tribes doing something together. So that wouldn't count as one of the three. Anytime that both tribes do something jointly, it's not counted.
Mr. Henry,
And maybe,
we've got to move on.
I understand, but maybe this will help clear up. The last sentence when we're talking about the 3-trip requirement says, however, if a tribal council member is required to travel outside the jurisdiction on official Cherokee Nation business, such limitation shall not apply. And we can clarify that language, but that's the intent.
Thank you, Mr. Henry. Moving on down to new business. Item 1 amends the sales tax code. Mr. Hoskins, disabled veterans.
Thank you, Madam Speaker. Yeah, very briefly, this does add an exemption for sales tax to 100% disabled victims. And just by way of example, if a disabled veteran purchased
Would be quiet, please. He speaks very softly.
If a disabled veteran were to go in our gift shop and present her 100% disabled card, she would be.
Moved in second. Any discussion? Call for question. All in favor, signify by saying aye. All opposed, same sign. Thank you, Mr. Hoskins. Item 2 is an act amending the licensing and tax code.
Thank you, Madam Speaker. This follows up on some earlier legislation. It's more precise. It's the language as to the mini truck. It tracks state law and federal regulations. It also does the same with off-road vehicles. I move for its approval.
Second.
Moved in second. Any discussion? Call for question. All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Item 3 is the waiver of sovereign immunity by Mr. Buzzard.
Yes, this is a resolution to limit the waiver of sovereign immunity to move forward with the purchase of the nursing home in Jay for the home health service to go back and purchase that particular building up there for business. I move for its approval.
Second. Moved in second. Any discussion? Mr. Buzzard, what limit does it put on the...
Yes, and I can ask Melanie Knight or Rick Richards to come up to give us further information on this.
Madam Chair, the note in question, the limit will be $900,000 for total purchase price and operating capital.
That's the only limitation on our sovereign immunity. Mr. England?
Rick, while you're up here, Brad and I are concerned, has this got that project on it interfering at all?
No, sir.
Jordan, did you have anything to... No. Okay. Do I have a motion and a second?
I second
I believe you did.
Okay. Any further discussion? All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carried. Okay. Are there any announcements? I just have a question. Jody, how's the people over there that are affected by the ice storm, or Mr. Crittenden?
We're still out of electric and refrigerators going down. They brought in them MREs to eat. They said it might be another 2 or 3 weeks.
2 or 3 what?
Weeks.
Oh, mercy. Before you get any electricity? Wow.
Well, all of it.
But the chief has really been working with us, hasn't he, Joe?
Yeah.
Cherokee Nation's done a lot.
And actually, that line extends from the Briggs area through Adair County. I believe Mr. Baker is still without electricity.
John's still doing stuff.
Big areas over there.
Melanie, do you have a Brief report
I
on
can,
that.
I can make a brief report. We've been supporting the local shelters, the feeding stations, the fire departments with water, MREs, and support. And then also, based on a recommendation from Jody, which was a good one, we hired day labor by the day, just put people on by way of a contract to do tree cutting and had them join our crews and sent them out. First priority was just to get the roads clear, and now our priority is to get elderly and disabled their driveways clear. And so they've been working on that, and I think they expected to finish that this week, the ones that they knew about. So that's been a very successful project. And I wanted to also personally thank Jody because we've been contacted by her every day and multiple times a day about people, or things that she saw needed to be done, and it really alerted us to, where we needed to be. So I appreciate that. Thank you.
I appreciate how much you all's helped me, Melanie, if I had electricity.
You wouldn't have been out of your house.
Thanks a lot, electric, I'll leave you alone.
But we got a report this afternoon from Ozark saying that they're moving along faster than they thought they were going to be. They report now that they have 9,000 customers still out, and that's including Arkansas and us. And we haven't yet determined how many of those are just Oklahoma customers, but probably a significant amount of them are.
Thank you. Entertain motion to adjourn.
Get in 10 minutes.
10 minutes to adjourn.
Second.
All in favor, signify by saying aye.
Aye.
Opposed, same sign. We are adjourned.
Did everybody get that?